Arbitration at Sultan Al-Abdulla and Partners. And I'm delighted to introduce our speakers today. They are Lord Thomas of Cunwith, Paul Lowenstein, and Sarah Masters. Lord Thomas needs really no introduction. He's the former Lord Chief Justice of England and Wales, and currently the president of the Qatar International Court. He's also a commercial arbitrator. And Lord Thomas will be talking about security for costs and claim from courts and tribunals. Paul Lowenstein is a barrister at 20 Essex, specialising in commercial litigation and arbitration, with perhaps a specialism in matters of civil fraud. And Paul is going to be talking about injunctive relief from courts. Sarah Masters, likewise, is a barrister at 20 Essex, specialising in commercial litigation and arbitration, and she sits regularly as an arbitrator. And Sarah is going to be talking about interim relief from emergency arbitrators. And the way this session is going to work is that each speaker is going to present on their topic in order for about 10 to 12 minutes. And when everyone is finished, I will ask some questions as moderator, and then we welcome questions from the floor, and hopefully we'll have a lively and engaging discussion. So without further ado, I'm going to introduce Lord Thomas, who is going to talk about security for costs and claim from courts and tribunals. Lord Thomas.
Good morning, and thank you very much for your kind introduction. It is useful for me to be able to look at this from three different perspectives. First, as a former judge of the Commercial Court in London, where I was a judge just after the Arbitration Act of 1996 had been brought in, and there was therefore a much clearer basis on which all these powers could be exercised. Secondly, in terms of time, as the president of the Qatar International Court, which has introduced an arbitration law based on the model law, and where the court now has jurisdiction in claims where the arbitration clause makes the court the seat of the arbitration, and thirdly, as an arbitrator. And so I think it is useful in this particular subject to have these three perspectives, because there is no doubt that the approach of each has been governed to an extent by the conditioning, if I can use that term, with which people have developed and the legal culture in which they live. And I think it's helpful to begin by, first of all, looking at the position of the tribunal, because as most rules and most curial laws make clear, it really is for the parties to go, whether it is for security for costs, and I'll come to the distinction between the approach of the common law systems and the broader systems in a moment, and where one can see immediately there is a slight division in the way in which matters have developed. But from the point of view of the court, of the tribunal, the important provisions are to look at the rules and also to look at the curial law. Now, the curial law, although they differ from state to state, these days the majority, as everyone knows, is based on the model law, and that is what Qatar now has. Based on the original model law, rather than embodying some of the changes made in the 2006 revision. The English Arbitration Act, of course, postdates the original model law and contains very detailed provisions. But broadly speaking, most laws in laying down the powers of the tribunal accept that there should be a broad power to grant secure measures to obtain security for the claim, and some, particularly those influenced heavily by the common law jurisdictions, make express provision for security for costs. So I don't think the curial law doesn't really make a lot of difference. What, however, is important is the difference in the rules. Those heavily influenced by the common law, such as the London Court of International Arbitration rules, make very detailed provision for security for costs. Others do not. and you have to try and spell out of the general powers for security a power to order security for costs. And I think here there is the cultural division as to the approach. Those which have the express power, and the LCIA is one of the clearest, have come from a background where security of costs is not unusual. And those who come from the continental tradition, and one sees that a country such as Qatar is heavily influenced by the civilian law tradition, it is a question of, can you get that out of the general provisions and the rules for security? And therefore, I think one sees immediately that first difference. Now, the second area to consider is, do the courts have a residuary power, and what is the extent of their residuary power? Because almost all jurisdictions take the view that you really ought to go to the tribunal if the tribunal is properly constituted. Obviously, you need the tribunal, the courts for enforcement, and in some laws, it permits recourse to the courts if there is need for the intervention of the courts where the arbitration tribunal is incapable of acting. And in some areas, as provided for in the 2006 revisions to the Ancestral Model Law, where it's necessary to go to a court other than the curial court. And what is quite interesting is that most jurisdictions obviously have to consider whether the arbitration agreement prevents you going to the court. And it's the LCIA, which exceptionally probably has an express power for security costs, expressly prohibits by the arbitration rules recourse to the courts for security for costs. Now, it seems to me that it is important when looking at the way in which courts act to look very carefully, and you have to look very carefully at the provisions, the rules, but more importantly at the culture. And in my view, you can see this if you contrast England and Qatar, where the Qatari rules follow the civilian tradition, and you have to look to the construction of the rules to see whether you can spell out of the power to provide for security an additional power for security for costs. And then I think the third topic, which I want briefly to introduce in this short introduction, is the exercise of these powers. Now, the rules turn on 2 points generally. First of all, some impose a merits test. Do you have a certain threshold you have to reach? And secondly, they leave it to the broad discretion, either of the court or the tribunal. And I don't want to distinguish between the court and the tribunal in this, because the discretion, where granted, must be exercised on a basis provided for either in the rules or in the law of the court concerned. Now, I think it is quite important to bear very carefully in mind the approach that you take to the merits of the dispute when considering whether you ought to order security or security for costs, and the considerations as to whether you should grant it in a particular case, and if so, for how much. Now, in my view, one of the most important considerations to bear in mind is that if there is a merits threshold, and it's almost invariably you should have a merits threshold, either, for example, that in the model law of a reasonable possibility of success, that an arbitrator is on the arbitration tribunal, is very careful indeed in expressing views about the merits. My own experience is that although you say, well, of course, this is my preliminary review and I haven't heard this, that, and the other, it is inevitable that parties will take from what is stated in those reasons. And therefore, sometimes you see arbitrators go into the merits in some detail. I think this is unfortunate. You really ought to just set out the threshold test and in a couple of sentences say whether you think that has been met. The more important factor is balancing. And the factors that courts and tribunals have are broadly the same. If you're looking for security for the claim, you have to consider, is there a risk that the money won't be around at the time the award comes to be enforced? Or in the case of security for costs, is the claimant just bringing this with any security that the costs will be paid at the end of the day, particularly if arbitration is being brought by an insolvent company. Also, in security for costs, you have to take into account third-party funding, though third-party funding is not as common in arbitration as it is in litigation. Third-party funders tend to say that they think courts are slightly more predictable, and therefore, if you're putting your money on a case, you're more likely to want to do it on the basis of your experience of the courts. But third-party funding now being so common across both litigation and arbitration, if there is third-party funding and the particular claimant is not solvent, then obviously this is a very important factor in awarding security for costs, assuming that that is the approach you can take under the Curial law and under the particular rules of the arbitration. I think it's difficult to be more precise as to that sort of factor. But what is very, very important is to take into account the countervailing factors, particularly access to justice. You can't and should not, by requiring security for costs to be given, or by imposing tight security for the claim, deny the party against whom the order is to be made access to justice. And this is a consideration that firmly has to be borne in mind. And the other factor that is of importance is this a case where it is said that the conduct of the other party has brought the party concerned, whether it be the party against whom security for costs is sought or the party from whom security is to be ordered, has the financial condition of that party been brought about by the conduct of the other side? These are difficult considerations, and it's not always easy to balance them correctly, and it often poses people with a very real dilemma. And here I think one has a difference in the approach which one sees from the countries heavily influenced by the common law, particularly in England, maybe Singapore and Australia, and the approach that one sees from civilian lawyers, which is much more cautious, both as regards security for costs, possibly less cautious as regards the provision of security for the claim. But I do think that when exercising the discretion, whether it be wearing the position, or whether it be from the position of the arbitration tribunal, or I'm so sorry. I turned one phone off, but not the other. It seems to me that the important factor is the cultural difference. And one final word. One of the concerns that I think courts and arbitral tribunal have are two different approaches across the world, the common law approach and the civilian approach, and also the approach of different tribunals in different parts of the world and different courts. And I chair the steering committee of the Standing International Forum of Commercial Courts, which represents jurisdictions such as China, India, the UK, France, Brazil, and one or two countries in Africa, amongst the 40 or so members. And what we are looking at is trying to see if we can work more closely with arbitrators and with mediators to see if we can adopt a more consistent approach to these particular areas, and in particular, an approach that stops at the end of the day people abusing the right of recourse to the courts to avoid the enforcement that is ordered by any particular court if the arbitrator's award has to be enforced. Again, my apologies for the interruption of the phone, and I look forward to our discussion as we proceed.
Well, Thomas, thank you very much indeed. I'll now hand over to Paul, please, who's going to present on interim injunctive relief from courts. Paul.
Tommy, thank you very much indeed, and thank you to those who are listening today for being here. And Lord Thomas, thank you for the rather serendipitous but unplanned segue that you've handed me, because the theme I'm going to take is in relation to the enforcement of awards and interim measures that can be obtained in courts in England in support of that process. It sounds odd to say interim measures and then enforcement in the same sentence, but of course, there's no value in an award unless it can be enforced, and the enforcement process can often give rise to a greater battle than the original arbitral process. So I want to consider very quickly, first of all, the availability of what some people call the long arm jurisdiction of the English courts, the business and property courts generally, to secure assets to satisfy a court judgment, and then to look at how that differs in relation to awards. Firstly, where the award has been given, and I will only think about this very briefly, by an English arbitral tribunal, but I'm much more interested today in looking at the international dimension. So what will the English court do in terms of preservation orders and disclosure orders to aid in the enforcement of an award granted by a tribunal seated elsewhere than England, for example, in Qatar. Now, as many of you will know, the English court has developed, and Lord Thomas was at the very forefront of this when sitting in the courts in what then was called the commercial court, now the business and property courts with the commercial branch. But the English court will grant freezing injunctions and disclosure orders in aid of the enforcement of a judgment. And the test for obtaining those awards is slightly easier to hit or achieve than where one is seeking a pre-judgment injunction, because the good arguable case element falls away. Ipso facto, I've been told today actually not to speak Latin anymore. So by its very nature, you have an award, there is a good arguable case for the enforcement. And the only question is whether the rest of the test is met. The English court will also, generally under a statutory provision, section 25 of the Civil Jurisdiction and Judgments Act in England, lend assistance to the enforcement of foreign judgments. Those are judgments of foreign courts, and interim relief, it can be and is very regularly granted in those circumstances. So much for court judgments. Now we come to the arbitration element. What injunctive orders will the English court make to assist with the enforcement of arbitral awards? Well, where the arbitration is proceeding in England, for example, in the London Court of International Arbitration, then the Arbitration Act 1996, section 44 is absolutely clear, and it grants the court wide powers to grant emergency relief equivalent to its own powers in English civil proceedings to make, for example, preservation orders, disclosure orders, or even injunction orders. There are technical rules which in the end give supremacy to the arbitrators, and the arbitrators, if they make a subsequent award, for example, that will automatically discharge the court's award. That's all in the statute. Now to the international element. Set up the picture. What will the English court do where the arbitration is proceeding or took place in another state? For example, just to bear this in mind, for example, where the arbitration was seated in Qatar and an award was granted in that arbitration, but the assets are either in or connected to persons who have a connection with London. Now, the general rule, based on the judgment of principally Lord Donaldson in the leading case of Rossel and Oriental commercial shipping, is that no injunction will issue. Remember, the jurisdiction is statutory. Section 25 of the Civil Jurisdiction and Judgments Act operates. And the short point, which one could develop over time, but we're limited today, is that only in an exceptional case will the English court intervene, and it should stop, and I'm now quoting from the judgment, it should stop short of making orders which extend beyond its own territorial jurisdiction. So far, so bad. You want an award, you want to enforce it in England, or obtain an injunction in England, you generally will not be able to obtain such an order. And that, you may think, is a very good thing, because there are arbitrators available in the place of the seat, there are courts available in the place of the seat, and the English court, by reference to the statutes, has limited its scope of operations. But that's not the end of the story, because under section 44(2)(e) of the Arbitration Act, as I've said, the court is empowered to grant interim injunctions in support of arbitrations. And a little known provision, or little regarded provision, section 2(3) of the same act, makes it clear that that power is conferred even if the seat of the arbitration is outside England and Wales. And so you may say, and people do, there are very wide-reaching territorial orders that can be extraterritorial orders that can be available. What are the limitations? Well, again, to cut through this, the English court has self-imposed a test of appropriateness, or in fact, as the court judgments put it, inappropriateness. The courts will say, we have the power, but should we exercise it? And in cases such as Mobile Cerro or Cerro, Mr. Justice Walker, the courts will look at whether or not it's appropriate to make an order, the appropriateness test being the touchstone by which the exceptionality feature has to be judged. Now, these provisions have been tested on a number of recent occasions, and one can see a general trend of the continuing reluctance of the English court to make injunctive orders to assist with the enforcement of non-English arbitral awards. In Bow Trading and Bertel Nordling, Court of Appeal 1998, it was held that the Rossiel case established a guideline that should be followed, save in exceptional or special cases. So it wasn't just confined to its facts. The court was elevating it to a guideline test. And on the facts in that case, no injunction. More recently, in 2018, Mr. Justice Butcher in the Commercial Court, the case called EEEL, or Eastern European Engineering Limited against VJ, followed both Rossiel and S&T, and as in many of the cases, applied section 44 of the Arbitration Act, but also took into account the jurisprudence, which is much broader, under section 25 of the Civil Jurisdiction and Justice Act by analogy. And there again, no injunction granted. So why am I bothering you with this set of negative results? Is there nothing that can be done? And the answer is there seems to be a developing jurisdiction. And that is in international fraud cases, which is the area in which I have the greatest, although not an exclusive interest. In international fraud cases, one sees a greater willingness in the courts to grant injunctions where, to put it shortly, the arbitral award is granted outside England and the case appears to have almost nothing to do with England. The high point so far is the now quite well-known case of ArcelorMittal against SR Steel 2019, Mr. Justice Jacobs. The facts are stark and the result is interesting. Very briefly, on the facts, there was a Minnesota-seated ICC arbitral award against SR. The Ontario court held that SR's dealings with its Ontario subsidiary had been oppressive to the subsidiary's creditors. SR, and this is important, had transferred away over $1.5 billion and then withdrew from the arbitration. The tribunal awarded $1.3 billion. As the award was registered in England, and wide injunctive and disclosure relief was sought in aid of enforcement of the Minnesota award. There was evidence, and this was another important point, that there were persons and papers in England. See so far that the case got nothing to do with England. There were evidence that there were persons and papers in England which might make the award more readily enforceable. Justice Phillips, after a contested hearing and in a long judgment, granted injunctions and disclosure orders, and I believe search orders, even though the underlying case had no clear connection with England. Following the case of ConocoPhillips China against Greco Energy 2013, he held, and there are, to my mind, four important holdings. First, that there was strong evidence of international fraud, and where that arose, the English courts would be more willing to intervene. See cases such as Duvalier and Haiti. Secondly, the attempted dissipation of the 1.5 billion asset in the face of an arbitration award itself warranted intervention. The English court would not just stand by and watch. Third, the fact that there were persons and papers in England that could identify hidden assets was held to render such orders just and convenient. And fourthly, there was no legal obstacle to serving the injunction or the disclosure orders out of the jurisdiction, even where that relief had not been sought in the arbitration claim form put before the English court. So foreign award, arbitration claim form in England to lend assistance, arbitration claim form fell short of seeking the injunctive relief, but nonetheless, the court went on to grant the relief. So there seems to be an expanding jurisdiction. It is quite limited, and we will have to see how it develops. Maybe we can pick that up when we come to the questions and answers. Tommy, I think I've come in with 12 seconds to spare.
Paul, that's perfect timing. Thanks very much indeed. Now on to Sarah, please, who's going to talk about interim relief from emergency arbitrators. Sarah.
Thank you very much, Thomas. Hello, everybody. I'm going to address some remarks about emergency arbitrators. I'm obviously getting quite long in the tooth because I thought, goodness me, this is quite a new thing. And then I actually looked and realized that actually this is a creature which is now more than 15 years old. It was first introduced as long ago as 2006 by the IDRC, who brought in a new procedure whereby parties could seek emergency interim relief from an emergency arbitrator before the constitution of the tribunal. Now, since then, in that characteristic way of arbitration institutions following each other, it's been incorporated into the rules of most of the major arbitral institutions with certain tweaks and peculiarities. So we see it was adopted by the Singaporeans as in 2010, and also by the Stockholm arbitration then, ICC 2012, HKIAC 2013, LCI 2014, procedure well known under the ICC and also under many of the different regional arbitration institutions. Now, in 2019, the ICC commissioned set out a report where they described the rationale for the emergency arbitrator development, what being as many institutions seem to have determined that the emergency arbitrator fill a perceived void and satisfy a demand from users. Now, I'm going to ask rhetorically, and it's a question which I would very much seek comments from the participants to this webinar. Is that right? Do they? Is there actually a real demand for emergency arbitrators, and how widespread is their use? And at the end of my presentation, I will give my own anecdotal experience of that. Now, I'm going to deal then with three matters. Firstly, I'm going to talk a little bit about why it was perceived that there was a need for the emergency arbitrators. Secondly, I'm going to give some views about the relative pros and cons of going to court for interim relief versus going to emergency arbitrator. Thirdly, I'm going to talk about what I think has been one of the most widespread perceived difficulties with the procedure, which is the enforcement of the orders or awards of an emergency arbitrator in circumstances where there is not compliance by the party against whom they're addressed. And fourthly, I'm also going to talk very briefly about the types of orders that one can seek from an emergency arbitrator. Now, firstly, dealing with why they were developed. Now, there are, many, many reasons, but it seems to me that there are probably four principal reasons why they were thought to be a good thing. Firstly, there was a perception that court support for arbitration in the form of interim measures in some states wasn't satisfactory. And indeed, in some states, there was no possibility of interim relief at all. Or in some states, it was thought that the courts were slow, delays, and we needed a more flexible and speedy process was required. Another significant, in my view, critical point is in relation to the development of the jurisdiction is confidentiality and party autonomy, which underpin the whole process of arbitration. Now, as doubtless you're all aware, confidentiality may be a critical factor as to why parties seek arbitration rather than bringing their disputes before the national courts. And in the event that you are forced to go to court for interim relief, you will often, but not always, lose your cloak of confidentiality. And that, for many, is perceived to be a problem with proceeding before the courts. Turning then to the factors favouring or disfavouring applying to the court versus arbitration. Firstly, speed. Now, I would suggest that actually that's pretty neutral. The institutional rules provide for decisions to be made speedily. You're usually talking about a few days or a couple of weeks. But equally, certainly in the English courts and in the commercial court, one can get before a court extremely rapidly if you need to. Our judges, as Lord Thomas doubtless remembers, sit late in the evenings, at the weekends, even in vacations. So I don't think that there is much to be made of the speed point. Flexibility. The institutional rules are very flexible. They generally grant substantial discretion to the emergency arbitrator regarding the procedure to be used. Depending upon the urgency, you may or may not have a hearing, although certainly in my experience, the preference is arbitrators, as you know, like to hear the parties if they possibly can do. And so generally speaking, there is a preference for a hearing unless it is not possible at all. Cost. And the costs are relatively modest, and in a large dispute will be a mere drop in the ocean. Ex parte relief. Now, it seems to me that this is still a factor which favours heavily in favour of the court. Now, under hardly any of the rules make express provision for ex parte relief to be given by an emergency arbitrator. I believe there is provision made in Switzerland. There is some flexibility in some of the institutional rules. For example, the LCIA rules talk of each party being consulted if possible, which would suggest that if it was sufficiently urgent and sufficiently serious, you might be able to persuade an arbitrator to at least provide some sort of provisional relief to hold the ring pending a hearing. But I would suggest again that the background and experience of arbitrators, which is very much versed in party autonomy and the right to a fair hearing, is that virtually all emergency arbitration applications will be on notice and will be heard. The arbitrator will wish to consult all parties unless there is serious urgency and a serious reason not to. And even if they're not, the type of relief you will get is likely to be extremely limited and only pending the possibility of a hearing. And again, the courts, I mean, you can contrast that with the courts, whereas provided you have good reasons, you can go ex parte speedily and efficiently. Further factor, relief against third parties, very difficult, of course, given the nature, the contractual nature of arbitration. And I'd suggest that's still heavily weighted in favour of the courts. Just briefly as to the types of orders you are likely to receive from an emergency arbitrator. Again, there are infinite varieties, but 4 main ones that people tend to be looking for. 1, preservation of evidence. Secondly, preservation of assets, which of course dovetails nicely with both what Lord Thomas was speaking about security for claims and also what Paul was talking about in relation to enforcement. Thirdly, injunctions. Maintenance of contracts in force where one party is seeking to terminate and the other side says it's wrongful. Those are, there are many more, but those were the main sorts of relief that came to mind to me when I was thinking about what I was going to say to you this morning. Now, a few words then about enforcement. Now, this, I think, has always been a critical issue in relation to the attractiveness of obtaining relief from emergency arbitrators. Hitherto, it's been thought to be a real difficulty. And I think there has been a perception that if parties don't comply voluntarily with an order granted by an emergency arbitrator, the courts will not enforce them. Now, there's several reasons for this. Firstly, there's the form of the relief. Some rules, I believe the ICC rules mandate that the relief has to be the form of an order. Others say it can be an order or an award, but whether or not, whatever the form and the wording used, there's been issues as to whether or not it is properly an award that is enforceable under the 1957 New York Convention. Secondly, the status of the arbitrator. Is an emergency arbitrator a proper arbitrator? Thirdly, the fact that the relief granted is provisional rather than final. And usually what tends to happen is when the tribunal is appointed and has a chance to convene and consider the matter properly, they may decide whether or not to maintain the relief in force or set it aside. But however, there have been a number of pro-enforcement developments in this area. Firstly, in Hong Kong and Singapore, both have enacted legislation saying that the awards of an emergency arbitrator are enforceable. Now, so that is a pro-enforcement development, but of course that only works if you're seeking enforcement in those jurisdictions. I would suggest perhaps of more significant is the decision of the Indian Supreme Court last year in the Amazon case, where the Indian court found that an emergency arbitration award of an Indian-seated SIAC emergency arbitrator was enforceable. I think that was considered by those in the international arbitration space as a very significant decision. And then finally, wrapping up, anecdotal experience. I asked my colleagues yesterday, walking around chambers, what they thought about it. And also I was at a Chambers dinner last night, and general consensus is, yes, interesting idea, very good, not actually come across it in practice. Now that may have something to do with the fact that I was in London and I was asking English barristers and barristers, perhaps unsurprisingly, tend to think that the English courts do a good job in supporting international arbitration. But there has been one controversial development here, though, as well, which, although seeking to be supportive of emergency arbitration, has perhaps turned out rather counterintuitively to have the opposite effect. There was a decision a few years ago in a case called Gerard Metals, which concerned the LCIA rules, where the judge refused to grant interim relief from the court on the basis that the parties had previously invoked the emergency arbitration provisions and gone to the LCIA, who had refused to grant interim relief. Now, it may be thought that that was a case that turned on its particular fact, but it has led to a concern that if you adopt institutional rules which include emergency arbitration provisions, which is most of them these days, that you are effectively not going to be permitted to go to the English court. And so what it has led people to do is, in a number of cases, is to amend their arbitration clauses to make clear that the emergency arbitration provisions don't apply. That has led to some concern. We are currently reviewing our Arbitration Act here, and there are some suggestions that one of the amendments that will be made will be to reverse that effect of the decision. Now, then finally, my own practical experience. Now, I have actually come across emergency arbitrations. I've had three. I've had one where I've sat as an emergency arbitrator, one in a case where I was an arbitrator who was appointed after an emergency arbitration application had been made, and I've done one in counsel, as counsel. They were generally, my experience was generally a positive one. However, the interesting thing, and it may be it may be that this is the experience of others, is that in each of these cases, they were effective in order to ensure compliance before the application was made. So in none of the cases was there actually relief granted by the arbitrator. In each case, the merely making of the application led to the parties sitting down and discussing and coming to an arrangement which enabled the reference to continue without the grant of relief. Thus, I would say is one of the great positives of international arbitration. And indeed, it seems to me one of the practical effects, certainly in the cases I've been involved, of the emergency arbitrator provision. I don't know if I've been too long or much too long, but that was all I was going to say, and I welcome questions from you, and I would even seek to answer them. Thank you very much.
Sarah, thanks a lot for that. So we have a question already in for Lord Thomas, and it leads to a question that I was in fact going to ask him. And the question that we've had in from the audience is this: thanks to Lord Thomas for an informative speech. My client is a claimant and they have an arbitration against a bankrupt defendant. Can I ask the tribunal for security for costs? And what do you think about asking the tribunal for security for claim? Grateful for your reply. Now, I don't want to answer on behalf of Lord Thomas, but you can always ask. The question is whether you'll get it. And it leads me on to my question in relation to insolvency, because the only time I've ever applied, unsuccessfully I might add, for security for claim and costs was in the context of the counterparty's insolvency. And it's often said that you accept the risk that your counterparty might go insolvent, and therefore you should never get security in those circumstances, even if at the start of the commercial relationship there's no hint that the counterparty was in trouble, or even at the start of the arbitration there was no such hint. Lord Thomas, what's your view on that particular opinion? Do you think that that holds water? Would such a submission curry favour with you? Were you an arbitrator?
I don't think it matters whether you're an arbitrator or a judge approaching this. If a party is bringing a claim and that party is insolvent, which is not actually the circumstances asked, then I think unless you're denying someone access to justice and there are extenuating circumstances, it seems to me this is a case where you ought seriously to consider security for costs. What I mean by denying access to justice is that you should not use the tribunal's powers or the court's powers to stop someone bringing a claim. But if it depends on the feel of the merits, depends on all the circumstances, but that is certainly a case where I think you ought to do it. On the other hand, if you're a person bringing a claim and the party on the other side is insolvent, it seems to me the circumstances will be rare where you ought to be able to obtain security for costs, and probably rare where you will obtain security for the claim unless there's any evidence in either circumstance that party has been putting his assets beyond the reach of the court, because the word insolvency covers the causes of insolvency can be so extensive. So I think it's very difficult to be precise in these cases. The third thing I ought to add is that what is critical is the rules and the cultural background. I think that if the cultural background is more influenced by the common law and less by the civilian law, you're more likely to get it than the other way around. What we will be trying to do in Qatar, because we are influenced by both, is to take a road that steers neatly down the middle. But that is jurisprudence we are in the process of developing.
Well, Thomas, thank you for that. There's another question in about the assessment of the merits of any application for an interim measure. And you addressed that at the start of your presentation. I've always approached it on the basis of, well, is the prima facie merit to your position? And the questioner has adopted the same line and said, well, if prima facie is the right way of looking at it, does that test apply equally to a procedural right that you're seeking to vindicate by way of an interim measure, as much as it does in relation to something of a more substantive nature? And the questioner is asking about preservation of evidence, an injunction to preserve evidence. And would you require a different test to get an injunction to preserve evidence than you would, say, in relation to getting security for costs?
I think there are two different ways in which you look at this. I think as an arbitrator, because you are going to be sitting in the case for the future, you've got to be very, very careful about views you express on the merits of the claim. It's unlike the position in a court where, if it's an arbitration application or we need a court hearing, it's unlikely you'll be involved in a merits dispute. So you can probably take a slightly more robust view. And I think, therefore, if as is set out in the model law, provisions analogous to it, a real possibility, you have to have something that shows there is a good ground for it. As regards preservation of evidence, obviously you've got to meet that initial threshold, but it depends on the intrusiveness of the application. And the more intrusive you want to be, probably the higher the threshold you have to meet. This is more a question of feel than of jurisprudence. But generally speaking, the more you wish to interfere with someone else's business, for example, or the more what you're likely to do will affect that person's business, the stronger the case is you have to show as regards an interim measure to seek to preserve the evidence. But if it's something where it's not really going to have any effect on the other side, then you could be a much lower test.
Lord Thomas, thank you for that. Question for Paul, if I may. I think I understood from your presentation that the English court is more likely to grant enforcement injunctive relief in aid of a non-English award where international fraud is engaged. Where do we go from there?
Well, it's only a guess, but the nature of fraud litigation is changing fast and will be forced to change faster by the nature of the assets that one's litigating over. We're on the cusp of seeing an explosion, I think, in litigation over digital assets. And arbitrations are already being brought to secure the ownership and possession if you're going to characterize these assets as property, of, to put it bluntly, digital assets, digital coin, non-fungible tokens that have been stolen, often by somebody interdicting your digital wallet, or by hacking an exchange, or by playing fraud at the exchange. As these cases develop, there will be a need for very swift remedies. And once enforcement and once arbitral awards have been granted, there will be a need for an effective system of international recognition and enforcement of those awards because of the nature and free-flowing movement of those assets. If something is everywhere and nowhere, if something is stored on the blockchain, as most of these assets are, then one will need to develop the jurisprudence to allow more effective tracing of them and more effective securing of them and information in relation to them. And in case anybody wonders whether this is relevant or not in the world of international arbitration, I know to my certain knowledge that at least one of the world's most prominent international digital coin exchanges enters into, with its standard contract with all the people who use it, there's an arbitration agreement for the settling of dispute. That's Binance, and a Hong Kong arbitration is stipulated. Now, if that is the case, then if you want to go against the exchange, or the exchange wishes to go against you, then on the strength of the agreements, you will have to arbitrate, but you will need to draw in injunctive relief, often in several different jurisdictions at the same time. So I think watch this space. A lot of people are saying it's all coming, it's coming quickly. Well, it is coming, and it is coming quickly. And arbitrators are going to be asked to tackle difficult questions, such as the nature of digital assets. Are they property? Are they money? Or are they something different? The English courts are saying, at least on a good arguable case basis, that they are property, based on a very thorough report written by a number of clever barristers, two of whom I'm pleased to say are in our chambers. But others may take a different view. And just a further glance down the telescope into the digital asset, digital coin world, and we're on the point almost of central banks issuing digital coin. And there's a suggestion, for example, that the G7 group may together issue coin quite soon. If that's right, it will be interesting to see the characterization of those assets because of the legal techniques and applications that will apply to them and the analysis that will apply to them, and the basis on which disputes will be settled in relation to them. Because if they are truly international tokens, I'm trying to find a neutral word that neither says money nor property, then there will need to be some sort of arbitral set up, some sort of allocation of jurisdiction, some sort of access to remedies. And that is, I know, all being thought through now. I've spoken to people who are engaged on it. I hope that's a bit of a sort of crystal ball gaze, but it's coming.
Well, thank you for that. A question for Sarah, if I may. If you were advising a client, Sarah, who needed urgent interim measures, would you tell them to appoint an emergency arbitrator or apply to the court?
In London, I think, given it would depend upon, well, I think there are a number of factors. One, it depends on how urgent it is. As I've said, you can get instructed on Sunday morning, and you can get a commercial court judge if it's sufficiently urgent on Sunday afternoon. You're not going to get that with an arbitrator. Saying that, however, so if it's very, very urgent, I would say you should go to court. Equally, but then again, tied against that, confidentiality. If it is very hush-hush, if you really don't want people to know about it and you have a bit more time, then it seems to me that the emergency arbitrator jurisdiction may be more attractive to you. Thirdly, though, again, another factor is compliance. If you don't think the counterparty or the other side is going to comply, you may have a difficulty effectively giving your emergency arbitration relief any real coercive teeth. And there you do have, I would suggest, a greater force given by a court order.
Sarah, thank you for that. What would you say is the most exciting development in the area of emergency arbitrators?
I would say, firstly, that people like change, but are equally sceptical about change. And the more, as time goes on, the more people seem to be prepared to use the emergency arbitration provisions because they know better how it works. But I think that the single most important thing at the moment is enforcement, and the fact that the courts seem to be moving towards greater recognition and preparedness to enforce these orders as awards.
Sarah, thank you. And one last question for the panelists before we have to finish in 2 minutes, and that's for Lord Thomas, if I may. A question just in, which I think is a very important one. And the question is this: it's common knowledge that mainland Qatari courts do not grant injunctions against encashment of bank guarantees. Does the QFC court have a similar approach? If so, and in circumstances where a tribunal in a QFC-seated arbitration injuncts a party from liquidating bank guarantees, but that party violates the tribunal's order, what recourse is available to a non-defaulting party in the QFC court?
Sounds to me as if Lord Thomas ought to charge for this one.
I'm not going to attempt to explain the jurisprudence on what is quite a difficult area of law. Safe to say that what the QIC does is to follow broad international practice. And quite often, although at first sight it may appear that the practice is different between different states on matters such as performance bonds, there is now a much greater degree of international uniformity. But I'm not prepared in 2 minutes to go further than that. What I will say, however, is that if the QIC has a jurisdiction, if it has been made the seat of the Quril court for the arbitration, and in those circumstances, if it makes an order, then its order is enforceable in one of two ways. The QIC is not an extraterritorial court. It is part of the courts of Qatar and has an enforcement facility through an enforcement judge and can enforce its judgments in the state of Qatar. Secondly, there are, of course, arrangements with other countries for the reciprocal enforcement of judgments, and the QIC is no different to that. If you want information about how you enforce QIC judgments in other countries, or enforce judgments of other countries in the QIC, do have a look at the Standing International Forum's guide which sets out the memoranda of guidance of several countries written under judicial authority as to how you go about enforcing overseas. I can answer that much in 2 minutes, but the first point, I look forward to having a case where we can look at the merits of that in due course.
Lord Thomas, thank you very much for that, and thank you to all of our speakers for their excellent presentations. Thank you to those who've been listening for their questions, which have helped to have such a lively and informative debate. We'll now have to bring this session to a close. Thank you all very much indeed.